Good morning, ladies and gentlemen. I'm New York State Attorney General Eric Schneiderman. I want to thank you for joining us today for what we believe is a very important announcement, in fact, a groundbreaking announcement relating to the safety of children and the confidence of parents about their children's use of the internet. I'm joined today by several of the attorneys who have been working on this case for months, tirelessly. This is, again, a unique investigation, and we're pleased that it's come to a successful conclusion that has implications for the entire industry. Kathleen McGee, the Chief of my Bureau of Internet and Technology, Deputy Bureau Chief Clark Russell, and Assistant Attorney General Jordan Adler are with me, and I'm very proud of the work that they've done, that our office has done in this case. We're here today to announce a series of new unprecedented agreements that will end the illegal tracking of kids online on some of the websites of some of the nation's biggest media and toy companies. We used to worry about our children wandering into bad neighborhoods. Now our children live online, and we have to police the internet as we seek to police our streets. And today we take a major step towards ensuring that that is going to be taking place. When parents let young children use the internet, they should feel confident that marketers or irresponsible corporations aren't tracking their children as they surf. And that's because for nearly 2 decades, federal law has made it illegal to either collect or disclose the personal information of children under 13 on websites that are directed to kids. That means companies can't collect their names, their email addresses, without parental permission. In 2013, that federal law called the Children's Online Privacy Protection Act, or COPPA, got even stronger. Now companies are also forbidden from using cookies, IP addresses, and other personal identifiers to track kids on children's websites. This keeps marketers from targeting children and allows kids to visit kid-friendly websites designed for children, without the fear that their every click is being watched and logged by strangers. Now, while the law has been very clear on this, and it's a very strong law, it imposes a strict liability standard, which is very unusual in American law. The law is clear. What has not been clear is what companies have been doing to comply with it and how well they were living up to their obligations under this very stringent set of standards. So a little over 2 years ago, our office launched Operation Child Tracker to investigate what was happening on some of the biggest and most highly trafficked websites for kids. And what we found, frankly, was shocking. Many of the sites that are home to some of our most popular TV shows, toys, were littered with technology that can be used to track every move a child makes on that site. We saw it on the websites of Nick Jr. shows like Dora the Explorer and SpongeBob SquarePants, on sites for toys like Barbie, Transformers, My Little Pony, and Hot Wheels. The websites for all of these shows and toys were housing illegal technology that could be used to track visitors. Today, the companies that run these sites, Viacom, Hasbro, Mattel, and JumpStart, are being held accountable, and they have accepted responsibility for their duty to police their sites. It's important to note that the tracking technology was from third-party providers like ad servers, people who would post ads on the site, but have cookies that would follow kids. And as they navigated the internet, the cookies were not being put on by the host companies themselves. In some cases, the host companies were not even aware until we told them that the tracking technology was on their sites. And when we notified them, each of them took immediate action. But under the law, it is their responsibility to know what's happening on their sites and to police their sites. Child privacy laws hold these host companies accountable, and so do I. So under the conditions of today's settlements, these 4 companies will be paying a combined $835,000 in penalties for failing to protect our kids. But more important than that, they will also undertake significant reforms that will finally give parents the peace of mind they deserve when their children go online. First, Each of these companies has agreed to conduct regular scans of their sites to identify any third-party tracking technology. Second, and this is really critical, they're going to vet third-party vendors. So if someone wants to put an ad on your site, they're going to vet the vendors to see how those vendors collect, use, and disclose personal information, and make sure those vendors are following the law before they allow them to post ads on their sites. That's a really important step that we hope will become a model for the entire industry. And finally, they're going to update their privacy policies so that parents will know that the sites are complying with federal law and to give parents an easy way to contact them if they have any questions. These reforms and penalties will put all companies on notice, and all companies really should be on high alert because this is a strict liability standard, and that is very unusual, again, in American law, but appropriately so in this case. All companies are on notice. They must take responsibility and stop kids from being tracked on the internet. We will continue to monitor the parties that have entered into agreements with us today, Viacom, Mattel, Hasbro, and JumpStart, to make sure they're living up to their obligations. And our Bureau of Internet and Technology is not done with its work in this area. We will continue to investigate potential violations of COPPA. We will investigate violations of child privacy laws. Protecting our children on the internet is every bit as important as protecting them on our streets. And those of you who have kids know that life online has become a central part of most children's existence. So we have to deal with this the same way we deal with street crime. We're going to hold companies accountable who violate this law, and we're going to protect our children from the prying eyes of marketers and big corporations who proceed irresponsibly in spite of the law. I thank you for joining me today. We think these agreements are going to set a standard for the industry, and hopefully today we begin the process of restoring the confidence of parents that your kids are not going to be tracked if they're going online. So with that, we'll conclude, and if you have any questions, direct them to Eric Sufer, and we'll try to answer them.
Just state your name and outlet, please, and I'll call.
Oh, sure. COPPA. So what is done with the information that they're getting from the tracking?
Well, it's really for marketing purposes. I mean, you track people so that you can sell things to them. You track people so you can find out as much personal information as you can, so you can target advertising to them. You can steer them to something, and this has been an issue in the past, but with the internet, the risks rise to a whole different level. But there are people who are in the business of simply collecting this data and selling it for marketing purposes.
Anything untoward or illegal or something?
Well, the problem is we can tell if the kids are being tracked. We don't know what these companies do with the information. So we're pursuing that, but we want to make sure that there's a reason that we have a strong law that says kids under 13 can't be tracked, period. And that means we don't want them to be the victims of marketing legitimate products. We don't want them to be victims of scams. We certainly don't want them to be the victims of anything else.
AJ Ross, Channel 7 Eyewitness News. I understand the companies have a responsibility in policing their sites, but are there any penalties that are pending against these third-party advertisers, marketers who are also responsible?
The way the law is structured, the companies have the obligation, the primary obligation, to police their sites because they are the law is restricted to sites that are geared towards children. So that's really the way the law is focused. You are allowed to, and this is a discussion in many law review articles, and this is a discussion of the fact that adults are allowed to track. I mean, you are allowed to have an ad that is targeted advertising. So if you're interested in, you like Ferraris and you're interested in Australia, they will find that out about you and they will target ads to you to where you can buy a Ferrari in Australia, which to the extent that's your thing. Adults, it's pretty much open season, but we have very, very strict rules for kids, and that's what we're seeking to enforce here. But it's geared towards the sites that cater to kids. They are the ones who are responsible for policing themselves.
I understand that, but the companies that had the technology, the tracking technology, the third parties, they're not being pursued for them?
They are they're not allowed to go on those sites. They're being taken off the sites. There's nothing inherently illegal about them using the technology. They're just not allowed to use it on sites that cater to kids.
Thanks,
Quick question for you. For these companies, I mean, they're probably not the only ones out there that are doing this. So what would you say to parents on how they can protect themselves?
Well, if you're a parent and your kids are online and a targeted ad pops up, say you have a kid who's obsessed with Australia and Ferraris, and a targeted ad pops up on a kid-friendly site, then you know that someone is tracking your kid. Now, these companies have agreed to set up a very simple system for parents to interact with them, to find out information, to report complaints. We are hoping that this becomes the industry standard. And again, each of these companies accepted responsibility. In some cases, they did not even know this was going on. So we think today's agreements are tremendously significant because it really sends a message to every other kid-oriented site in the world that they are under an obligation and there is a strict liability standard that they have to police their sites. So we think this is going to have a big impact.
And you talked about a regular scan. What would you say?
A regular?
You said that the companies would have to do regular scanning or.
Yes.
What would you say is the time every month, every week, every day?
They're going to be doing regular scanning, but the most and I'm not sure if we have a particular timeline involved in this, but it's an ongoing process. But the most important thing they've agreed to is to actually vet the advertisers before they are allowed on. So no advertiser will be able to place a new ad on their site without the company having checked to make sure they're not putting cookies on, they're not tracking kids. So this is a proactive remedy going forward. And we are very hopeful that other companies will voluntarily adopt these standards. But as I say, our office is continuing to look into this in other areas. The overall investigation into child tracking is ongoing, and if we find other people violating the law, we'll hold them accountable too.
Hi, Christina Gershman, New York Post. Can you talk a little bit about why this is so bad? Like, what are the dangers in tracking children?
Well, children are susceptible to all sorts of scams and gimmicks that we hope that adults have the ability to deal with better than children. But child privacy, protecting our children's privacy, is tremendously important. We have laws that seek to protect kids in lots of ways that we expect adults to take responsibility for themselves. But if I have a kid who's going online, I don't want my child's activities to be tracked. I don't want there to be a dossier developed on my child that could be used in any of a variety of ways to try and scam them or just to show up later in life in ways that could be harmful. Kids don't have the judgment adults have. So we have a very, very bright line standard in this law, and it's actually, again, the discussion in academia about how dramatic the difference is. But for adults, it's really open season. But kids under 12, you can't track them. And I'm pleased that we have a law that is that tough. It's appropriate. I think there's an open debate about whether we need some tougher laws for adults also, but that's something that's an ongoing part of the discussion as the internet evolves and as the technology evolves and we deal with this new reality. But it has often been said that the internet is the crime scene of the 21st century. This is where the scams take place. This is where the crimes take place. And we have to be particularly sensitive to issues that relate to children's use of the internet. We don't want them to be victims.
More, Rich?
So is there any evidence any of these companies got paid to allow the third parties to go on their sites and gather this information?
Well, yeah, you get paid for advertising. Yes, I mean this is advertising. It's someone pays you to put an ad on your site, and the thing that's important to understand is the value to an advertiser of an ad that pops up once and the kid sees it once is a lot less than the value to an advertiser that can track the kid, and even if the kid logs out, logs back on, still can say, oh, that's little Joey logging back on. So this does have big implications in terms of the revenue stream. But yes, these are ads that people pay as they pay to run an ad in a newspaper or on a television show.
So did this investigation arise from a complaint about this, or just a general perception on the part of your department that there's something going on?
Well, actually, we were doing an investigation into a different matter altogether, and using one of our undercover computers, and the assistant attorney general who was doing that investigation saw an ad pop up that related to the previous investigation. So we're doing an investigation into payday lending, and someone went on a kid's website and a targeted ad about payday lending showed up, which indicated to us that we had a problem. And we started to look into this, and the more deeply we looked into it, the more we became aware that this was really an epidemic. And we're very pleased that these companies have responded the way they have, and we hope that other companies are going to voluntarily comply on their own.
Now, you had said that some of the companies did not know that this was happening. Can you tell us which companies did not know and which ones actually did know?
I mean, we're happy with the terms of the agreement. One company actually was in an FTC-approved safe harbor program, so they were using a vendor that was approved by the FTC, but there were some problems there, so we're working with the FTC on this as well. So we're reluctant to get into the terms of particular companies.
So how lucrative would it be for the Mattels and the Viacoms and the JumpStarts how much were they getting paid by these third parties to have these ads pop up or be allowed to do the track?
It's a wide range. It varies completely. I mean, I think everyone here probably goes online at some point in time and you see ads that pop up, and some pop up all the time. Some are big, some are small, and it varies from very small amounts of money to very significant ad buys.
And they're paying the major companies to be allowed to do that, but yet they're not getting vetted.
Now they are.
Mark,
Can we do off topic?
yeah.
Attorney General Scott Pringle, NBC News Radio. Just, given the position you're in, how do you feel about should the public know as far as foreign governments and the details of their donations to the Clinton Foundation?
As I think we've made clear, the New York State Attorney General's office has never required companies to disclose contributions from foreign governments. This is true of Democratic and Republican AGs. The history of this portion of our law and regulations has to do with a concern of abuse of New York State and local funds. So they've never asked anyone to disclose contributions from foreign governments. If we were to single out a specific nonprofit now and do that, it would be grossly unfair.
Do you feel that should be a law?
Well, we've been in the process of updating our laws and regs regarding nonprofits. They had not been updated when I took office since the 1960s. We've passed several, I think, excellent revisions to the law in the last few years, and we're looking generally at upgrading and improving the law, at both to keep up with the times and make the laws effective, but also to make it more user-friendly, easier to run a good nonprofit without making it unduly burdensome. So that's something that we're looking at as a part of our overall review of the statutes. But you should understand that no Attorney General of New York State has ever asked that question before. It's never been the way the law has been interpreted. So it would be very unusual to single out one single nonprofit and say, now we're going to start enforcing the law in a way we never have before against that one entity.
Can you help me understand, I know with Citizens United, I'm not too familiar with the case, but I know, you guys took it to court and you helped force them to disclose a lot of information, and they're, I believe, a nonprofit, right?
Oh, no, to us, yes. No, we do have information that we require nonprofits to disclose, and they were resisting providing information about donors. And as has been in the news a lot lately, there are always concerns about nonprofits collecting money for C3 purposes, charitable purposes that are then used for other purposes. And we have the duty and the right to investigate that, and that has always been done by the New York State Attorney General's office. So this is consistent with past policies, just that Citizens United chose to fight us. However, they obtained the funding for that fight. This is a subject of some interest, but we're just proceeding in the ordinary course. This is the way we deal with all nonprofits.
Okay, thanks very much.